Think it works? All righty. If you would, as we always do, let's begin this meeting. We'll bow our heads with prayer. Lord, we pause once again to thank you for this beautiful day. We thank you for all the blessings that we do have. We thank you for all those who protect these blessings for us, the men and women in our military and first responders. We thank you, Lord, for all we have here in the state of Georgia. We ask you now to give this committee the wisdom, as always, we need to do what is best for this state. Amen. All right. Chairman Welch, you have a couple of bills for us. You want to do your Superior Court bill first?
Yes, sir.
All right.
Mr. Chairman, members of the committee, the members of the Henry County delegation, which also represents the entirety of the Flint Circuit, which is made up of one county, Henry County, have all agreed and signed a bill for you. It's House Bill 786, bipartisan support for the appointment of a fourth judgeship for Henry County. In 2008, Henry County was due, under the old review and judgeship criteria, was due a position. 2008 budget cuts came in, recession hit. Henry County was put on hold with the support of the then sitting Chief Superior Court Judge Arch McGarity, recognizing the budget cuts that were coming, effectively held on that appointed position or that fourth judgeship. Since then, the Judicial Council has revamped its judge caseload counting procedures and done a thorough job of reviewing caseloads for metropolitan Atlanta counties, well, any county actually that was interested in applying. Henry County, the Flint Circuit applied and was determined to be out of the ranking, the second out of the top three circuits that would be due another judgeship given the caseload count. So what I have before you today is a bill that would enable the Flint Circuit to have its fourth judgeship for the Superior Court judge. And I will also point out to you that as an appropriator, and recognizing the differing budgetary priorities between the executive branch and the legislative branch, and recognizing that those differences also have cost involved, that in order to ensure that we are trying to do what we can in terms of recognizing the recommendations of the governor while also balancing the budgetary authority that we have under the Constitution, I have moved, and that's why you have substitute, we have moved the date for the beginning of this office to January 1st, as opposed to it starting July 1st. So it would be halfway through a fiscal year. So it would be January 1st, 2021, as opposed to July 1st, 2020. That will allow us to pick up about $200,000 in our current budget to be utilized elsewhere. And I will be recommending that to anyone else who is going to put forth a circuit judgeship to assist us with our budget as we move forward. That's the sum of it. If there are any questions about the bill, I would ask for the committee's favorable consideration of the substitute, which is LC 41-2279S for House Bill 786.
Questions of the author? Anyone? Okay. Well, hold on a second. Let's see if anybody wants to. Do we have anybody signed up to wishing to testify regarding House Bill 786? We do not. Okay. All right. Any closing comments, Mr. Chairman? Mr. Rutledge, why don't you press your button over there? Press the one next to you. There we go. Mr. Rutledge?
Do pass recommendation.
There's a motion to pass. Is there a second? Any discussion? Hearing none, all those in favor, please indicate by saying aye.
Aye.
You're off the rules. Do you have another bill, Mr. Chairman?
I hope I'm going to rules twice, but we'll see. Ladies and gentlemen of this committee, I bring before you what I perceive to be my most important piece of legislation, and I say I really mean on behalf of all of the citizens of the state of Georgia. What you have before you is House Resolution 1023 that was by substitute voted out of subcommittee This is an amendment to a proposed amendment for the voters to decide whether they agree or disagree with the proposed amendment, but it is to amend the Georgia Constitution, specifically Article 1, Section 2, Paragraph 5 of the Georgia Constitution. That current provision says what acts void, and it says legislative acts in violation of this Constitution or the Constitution of the United States are void, and the judiciary shall so declare them. In a recent decision, I say recent, 2017 decision by the Georgia Supreme Court, the Georgia Supreme Court had an opportunity to determine whether or not sovereign immunity, which is a constitutional provision in our Constitution, would bar declaratory judgment actions as to constitutional violations. And I'll share with you that in that opinion, they recited back to the Georgia Department of Natural Resources versus Sustainable Coast, where it was held that the doctrine of sovereign immunity would bar its suits for injunctive relief against the state. That has been extended to counties and local governments through a separate decision. In Oliveira v. University System of Georgia Board of Regents, the doctrine of sovereign immunity to bar lawsuits for declaratory relief was also found to exist. So you could not bring a declaration or seek a declaration from a court for violations of state law. Subsequently, in Lathrop, the question had not arisen as to whether or not sovereign immunity would bar a court's declaratory or injunctive relief for a violation of our federal or state constitution. But in Lathrop, the Supreme Court held that indeed the provision of sovereign immunity under our Constitution, state constitution, does bar such a suit unless waived by the General Assembly. We hold the keys to the courthouse for every single citizen in the state of Georgia as to whether or not they have access to petition the third branch of government for judicial relief when a state or local government has acted outside the scope of their authority, violated state law, violated our state constitution, or violated the federal constitution. If you don't surrender the keys to the people and unlock the doors to the courthouse, they will continue to be barred from entering. That is where we are. You have heard numerous bills that we have tried to pass, presented by Chairman Wendell Willard, House Bill 59 in 2015. That was passed by the House and the Senate and vetoed by Governor Deal. Subsequently, Chairman Willard tried again. It was held up in the Senate during the term of the 2017-18 term. In 2019, this committee considered House Bill 311 and voted it out, I believe, unanimously to the floor, where it was voted out unanimously to the Senate, where the Senate voted it out unanimously with modifications back to the House, and it was vetoed. If we are to give any meaning to the one sentence in the Constitution that says that the judiciary has the power to declare something void under our state constitution or the federal constitution, if you're to give any meaning to that, then we have only one option. Either we pass another law and hope that it makes it all the way through the process, or we put it to the people to amend the Constitution to give effect to the language of the judiciary shall so declare them void. This amendment is a modest step to just give meaning to that provision. You'll see the language does not provide for injunctive relief. It is simple declaration. It authorizes the General Assembly to consider that later on. There are no attorney's fees or damages authorized by this amendment. That could be considered by the General Assembly later on. And it is expressly in non-conflict with the other two sovereign immunity provisions of our Constitution. One against the state, and one as it pertains to municipalities and counties. Mr. Chairman, I would ask for the subcommittee is favorable consideration of the substitute to HR 1023. It's the LC number 412302S that's before you. And I'm happy to take any questions regarding that. I do have a proposed amendment to give some clarity to the dismissal provision that was raised in our subcommittee. I do support this amendment if you wish to put it on the bill, and I think you have a copy of that in your folders.
Thank you, Chairman Welch. Before we move to the committee with questions for you, I want to pause for a second and recognize a couple of our judges that I have with us that I should have done when we started. I was negligent. Please don't hold me in contempt. Judge Guy, good to have you today. Superior Court Judge, Brunswick Circuit, correct? What counties are those?
Camden, Glen Wayne, Appling, and Jeff Davis.
Oh.
All the L-shaped circle.
Okay, well, good. Well, we appreciate having you up today. You've been here before, and we always like to have judges with us to keep us straight, so we appreciate you. Judge Boyette, good to see you again. How are you doing today? Appreciate you coming. Pronounce your circuit name. Conesaga. All right, and tell us what counties it is.
Whitfield and Murray.
Whitfield and Murray. Okay. Is that in North Georgia?
That is very much in North Georgia.
Any further, you'd be in Tennessee, right?
Well, we border Tennessee.
Yeah. Well, everything can't be perfect about it, but it's generally pretty good other than that, right? Well, no, Judge, sincerely, we appreciate you being here today, both of you. Thank you all for being here. Chairman Welch has introduced the substitute to H.R. 1023 for us. It would now be appropriate for any committee members that had any questions about that. Number 12, is that you, Miss Oliver?
It's me.
Mr. Reeves?
Thank you. Chairman Welch, so I wasn't in your wasn't in the subcommittee presentation of this, and even though I know we've seen a lot of these before, that water's way under the bridge. So help me with number 3, line 28, and the General Assembly by Act may authorize injunctive relief for petitions filed pursuant to the paragraph. They may impose upon petitions filed administrative exhaustion, ante litem, sanctions or frivolous, statute of limitations. So this is essentially, tell me if I'm understanding this right. I get the second sentence, General Assembly may impose, meaning if somebody has not administratively exhausted their options, or they didn't give ante litem notice, or the statute is run, then they may, these petitions will be subject to these, and sanctions for frivolous petitions. So this is saying that a person who, if someone were to file a frivolous petition pursuant to your bill, the court would have the authority to sanction that person in whatever way they deem appropriate?
No, sir.
Okay. Tell me how to interpret that.
The General Assembly, by act, may impose any one of these requirements that would be subsequent to this. This provides a clear constitutional cause of action to seek declaratory judgment for a violation of Constitution or state law rights. This paragraph we're talking about, and the language you're speaking about, would be that the General Assembly, subsequent to the approval by the people of Georgia in adopting this amendment, could then enact a law that created some of these standard procedural requirements that would need to be met.
Sure. So, meaning we could then come back and enact a law that says you have to meet the ante litem requirement, or that they could be sanctionable. A frivolous petition could be sanctionable.
That's
right?
correct.
The General Assembly would have to put that into code.
That's correct.
And so when it says on line 28, where it says General Assembly may act by act may authorize injunctive relief for petitions. So that is, again, that subsequent action of the General Assembly, assuming that this passed a referendum, then that would be a subsequent action that would go back to the declaratory relief that someone would be able to pursue pursuant to your bill. Is that right?
After the fact, if the General Assembly thought that injunctive relief was important, and it needs to be on issue by issue comparison. So there may be issues that injunctive relief is not an appropriate remedy for certain governmental activities.
Mm-hmm.
For example, if there's an act done by an agency that we think is, well, the point of this language is for the General Assembly to look at a case-by-case basis under what circumstances would injunctive relief be necessary and should be proper versus not. As a constitutional amendment, it is designed to not be so verbose as to try to highlight every one of those circumstances, but to provide that general right of declaratory relief.
So what would be until the General Assembly, and I should probably know the answer to this, and maybe at one time I did, but I don't right now. If this were to pass a referendum, what effect would it have until the General Assembly came in and established some of these things?
So in paragraph 1, B1, which would be new language to the Constitution, would authorize a cause of action for declaratory relief, irrespective of any action filed under B3. So there would not be any need for us to prescribe by statute declaratory relief. It will have been done by amendment to the Constitution. So that will be a constitutional cause of action that the Supreme Court looked for in Lathrop. It looked to say, do we have any constitutional causes of action for which you can overcome sovereign immunity? So sovereign immunity is waived only by the Constitution or by the General Assembly. And so they looked through the statute and said, okay, look, there's eminent domain is one of those places where you can get monetary awards for damages. And that's a waiver. There are statutory waivers that may exist. But aside from that, there is no, and Olvera looked specifically at declaratory relief. There is no declaratory relief. And then the Supreme Court went on to look specifically at this subparagraph 5 of the Constitution and said that this language, that legislative acts that are in violation of the Constitution, if they are void, the judiciary shall so declare them, and said that that was not a sufficient cause of action to bring declaratory relief as a waiver of sovereign immunity. So paragraph B1 would be that cause of action for declaratory relief.
And so, and then along the same lines, number 4 obviously makes clear damages, attorney's fees, and costs of litigation shall not be awarded unless specifically authorized by act of the General Assembly. So in a similar fashion, it gives the General Assembly the ability subsequently to come back and say in these type of scenarios, then damages, attorney's fees, or cost of litigation would be appropriate.
That's correct, and we could do that on a kind of an issue-by-issue basis, on a subject area-by-subject basis where we thought it was appropriate.
You probably have talked through this. What other, how many other states have a similar construction?
Every state but 2 has a either statutory or constitutional waiver of sovereign immunity, either for injunctive or declaratory relief, or both. Except for 2, I believe, and Georgia's one of them.
Okay. And how many of the states have subsequently gone back and enacted provisions that allow damages, attorney's fees, and cost of litigation? Do you know that?
I don't know it because it's not relevant to what this measure would do. If we want to explore that later on, we certainly can. House Bill 311 actually also had this exact same provision, except for it allowed it in cases of 915-14 filings. So those motions could be filed, and you could obtain those for frivolous litigation. This one obviously would be a complete bar until we decided otherwise.
Okay. Thank you.
Ms. Oliver?
I'm sorry I didn't bring this up in subcommittee, and I've forgotten exactly the history of this, but on paragraph 3, lines 28 to 38 to 35, that is in essence a hypothetical paragraph. If the constitutional amendment were to fail, would paragraph 3 still be law?
It would still be law.
Beginning on line 33, you said a hypothetical that the General Assembly can preclude petitions by prisoners. On line 28, it's authorized certain sanctions, but line 33 is preclude petitions. Is there any case law on that in Georgia of a court precluding prisoner petitions? I don't know the history of that.
What line are you on? Ms.
33.
Oliver? 33.
33 through 35. 5.
I don't know if I remember a lot of discussion about that in the Court Reform Commission that I was on and some others were on. The abuse of one sort of prisoner who would repetitively file injunctive relief, but I don't remember if there's been any case law on trying to categorically deny a particular type of litigant
Well,
a right to the courthouse.
if you recall, the governor had vetoed 311 on the basis of that it would prohibit someone that was in a mental that was detained effectively by the state, presumably involuntarily. And in that context, the governor had said, well, we're going to veto this because it doesn't afford a remedy for 311, expressly did not afford a remedy for someone detained by the state or a local jurisdiction as a result of a mental condition. And so I expressly drafted this to address that very concern that the governor had raised in his veto statement. And in that way, it's open, the door would be open until we acted otherwise.
And again, this is a hypothetical based on a possible action in the future, and we could have that discussion at that time. This is not a reason for me to vote against it. I'm just curious whether any Georgia or any other state has really been successfully able to substantively constitutionally prevent a particular category of plaintiff from the courthouse door. Thank you.
Is that you, Mr. Holcomb?
Yes.
Yes, sir.
Thank you, Mr. Chairman. First, thank you for your continued work on this, and I think it is very important because right now the very first defense that's thrown up, even if the state is doing something that it shouldn't be doing, is sovereign immunity. And the other thing that I like that you've done here is addressing the issue of individuals and making the state the defendant or others, because my understanding is right now many people are named in both their official capacity and in their individual capacity as a way to try to get around the issues that are present. Is that a fair understanding of it? And if so, it seems like this would streamline some litigation and keep a lot of people from being named. And in fact, the amendment has the portion where it would dismiss individuals if they were just trying to be brought in their individual capacities when it's clear that they're really being named in their official capacities.
That's correct. And the amendment's kind of up for discussion on that point, but the emphasis of subparagraph 2 is to do what Representative Holcomb has explained. Presently, because you can't get declaratory relief because the sovereign immunity bars that against the state and individuals, what happens is that the only avenue that is open, and this is discussed in the Lathrop decision, is a theoretical, a legal construct. And the construct goes like this: if X person is an official, state official or local government official, if he or she acts outside of her official duties, then in that context, that person is not acting officially. They're acting in their individual personal capacity, because the presumption is that no one in their official capacity would do anything improper or illegal. I like that presumption as an elected official myself. But none of us are faultless. There's no government official that's faultless. We're all human. People make mistakes. People exercise a judgment call that may not be correct, or that may violate a constitutional provision that they may not have been aware of. That presumption, so the only effective way to remedy that under current law and current case law is to sue them in their individual capacity, saying you didn't operate in your official capacity because under that, wearing that hat, you would never have done this. But yet you did, because it's the only way you would have been empowered to do it, is to be in that official position. So you have to sue in mandamus, and the mandamus claim is really only to say, if you have a legal duty to do something, then I will compel you by writ of mandamus to do that. This doesn't resolve any situation where you've already acted. And so constitutionally and statutorily and case law-wise, we have no way for Georgians to go to their court and say, so-and-so messed up here and operated outside the scope of their responsibilities. And I want you to declare that action or the law that was imposed or the ordinance that was imposed, I want you to declare that unconstitutional or violative of state law. And we don't have that avenue now. And so mandamus doesn't even cure that situation as a cause of action. It only says that if you had an official duty to do something, the statute said you will do this and you choose not to, then I can order you to do that. But I can't order you to do something you've already done. It's not retrospective. Injunctive, the mandamus is prospective. So you can't go back in time and fix that problem.
And if I can just add
Sure.
one comment that may be helpful for the committee is I have some experience with this specific issue. I was involved with the lawsuit challenging the state's voting machines. And at the beginning of it, a number of people were named in both their individual capacities and official capacities. And the number of defendants likely would have been much, much smaller if we had something like this in play. But in order to even get to the courthouse,
You trying to help the bill or hurt the bill?
plaintiffs, well, I think it saves money by doing this because there's a lot less people who will be implicated if you don't have to go through
I know.
a little bit of the legal charade of, and it really is kind of a charade of the individual versus official capacities. But I am trying to help.
Yeah, and let me put one for the point on that. When you sue someone, we have a constitutional provision that says that the state and localities cannot expend taxpayer revenues for private concerns. It's the gratuities clause of our Constitution prohibits that. And yet, when you sue someone in their individual capacity, the state, either through the AG's office or through a SAG, a Special Attorney General, is providing a defense paid for by the taxpayers. I would submit to you that that's a violation of the gratuities clause. And I would submit to you that cannot be funded with state dollars. And so that would occur also at the local government level. Here you are having people that are running for boards of commissioners and city councils. They're trying to do the people's work. They're trying to do what we're doing here, working part-time, trying to be a good elected official, and they get wrangled into a lawsuit in their individual capacity. They're sued in their individual capacity, and yet local governments are forced with the decision of, do we fund the defense of what is effectively trying to overturn something that the collective did, the city council or the board of commissioners did? Do we fund that defense with public dollars? Or does the individual member of the city council or board of commissioners have to come out of their pocket or submit insurance claims to defend themselves? What are we doing to incentivize people to run for public office, to serve, if that's their exposure? This would stop that. Section 2 of this bill stops that.
Mr. Chairman, so starting with line 18 under section 2 that you were just referencing, I see the state there and all entities and subdivisions thereof. I see counties, consolidated governments, municipalities, or any officers, employees thereof. Where are school boards and all that? They come under.
They're
go
not.
ahead.
They're not here.
Okay. Why not?
What I was looking at were lawmaking bodies, people that either, enacted law or effectuated the enactment of law. School boards don't have that authority. And so I was trying to look at that from the perspective of what we were targeting was unlawful acts in the context of lawmaking bodies or officials.
I gotcha. Okay. Let's see, number 7 or number 8. Ms. Silcox, is that you?
Yes, I believe so. Thank you, Mr. Chairman. And I appreciate you bringing this bill back very much, Chairman Welch. And I guess I'm concerned about lines 28 through 38. Is there any, just because, to Representative Oliver's point, if for any reason the referendum failed and this was law, are we precluding anything? Or is this all inclusive? Is this all the scenarios?
It's a good question, and
Can I ask one question
yeah.
about that? I want to clarify what we're asking, because if the amendment fails,
Right.
lines 28 through 38 won't be law, right?
That's correct.
So maybe I'm trying to understand your question.
That's my question. I thought if this is passed by the General Assembly, that it would be law regardless of whether the amendment
This is all a constitutional amendment.
No, when I answered her
Okay.
question there's a
Okay.
different, we already have in our
We
current.
already have the ability to pass statutes to
That's
waive
right. So-
statute of immunity, and we've done that twice, and we
That's
got
right.
vetoed twice.
That's right. So
This is all constitutional amendment in front of you now.
So the law is
Okay.
is that we can adopt a law at any time to waive sovereign immunity.
Right.
We've tried that
Right, exactly.
3 times.
Right, understand.
So when to her question is a very specific legal question of whether or not the law is still in place. As I understood her question, that ability to waive sovereign immunity would still reside in the General Assembly and would be unaffected by this. If this does not pass, then by the General Assembly and then the voters, then this language does not become law. And so the ability for us to grant injunctive relief
It's still there.
still there.
Okay.
It's kind
Okay.
of restate.
Sorry, that was probably
Okay. It was just confusing
It
to
was.
me.
I
It
can
was
understand.
confusing. I appreciate that. Thank you.
you understand what I'm saying? Okay.
Okay, I
Okay.
appreciate it.
That is the truthful and accurate answer to her question. But this language
Mm-hmm.
itself does not become law until ratified by the voters.
Thank you.
Representative Bruce?
Yeah, in the interest of us non-lawyers, I just want to make sure I understand. Your intent is to try to protect people who hold public office from being sued individually for actions that they take or whatever on behalf of whoever they represent. Is that the essence of it?
That's what subparagraph 2
Okay.
does. Yes, sir.
So what happens in the instance where an elected official, in fact, is doing something outside of the scope of their duties as an elected official, and they're doing something that they ain't supposed to be doing? Does this stop that? Does that? You understand what the question? I'm trying to make
Yeah.
sure, because there are instances where some elected official doing something they ain't got no business doing,
Yes. So
and I don't want citizens to feel that they are not protected from those individuals.
So the second part of your question is actually under B1. B1 puts into our Constitution a constitutional right for each and every citizen of Georgia to sue in court, to get into court, because you can't get there now, just simply to say that what this official did, or what the city council did, or what the General Assembly did, or what a Board of Commissioners did, violated state law, violated the Constitution of the United States or the state constitution. That opens the door, the first subparagraph B1. B2 just simply says that when you bring that suit, you're not going to bring it, or it will not be maintained against the individual. It's brought against the city council, brought against the county, the city, the state, not brought against all of us as members of the General Assembly in our individual names, not brought against the entire city council. So the protection of 2 is that we don't get sued individually for doing what we do as an official in our jobs. No different than the city council. So if you file an action against the city and you want to sue the mayor and city council, then now you would sue them in their names. So you specify each name, John Smith, Susie Q, whoever. You name them individually. This would say you can get the relief you want without naming them. You would name the city of whatever, X. And that's who you're suing. So that's the distinction.
If I could, and I understand that, but my concern, I'm just trying to make sure I understand, is that even in the capacity that you're talking about now, me as a taxpayer, I'm going to be paying the bill for what an elected official did that might be outside the scope of their duties and responsibilities. So if that's the case, if let's say a case costs $100,000 or whatever to adjudicate, and it's determined that this action that the city has paid for was really not the city at fault, but the individual was at fault, how do you recover those expenses that were paid on behalf, because of the lawsuit?
Well, you wouldn't recover those expenses. What you're doing is that the lawsuit would be brought against that individual. So if it's a if it's a mayor or a city council member, you bring that suit against the city. City pays to fund the defense of it. And if the city believes that the action is legal, is proper, then they defend it. If the city does not, then the city would settle the case or the court's going to declare them in.
Okay, but I guess what I'm not getting at is how do we hold the elected official that is guilty of working outside of the scope of their office, how do we hold them accountable for that? Because this sounds like
the ballot box.
Well, okay.
None of the bills that we have passed waiving sovereign immunity would address that particular issue. The bills that we've passed is just to open the courthouse up so that you can get released. Because right now, that person can act with impunity.
Yeah, I guess the challenge that I'm having understanding this is that if you commit a crime or if you've done something wrong, and I'm suing the city because of what you did, and the court says, well, the city is not guilty of what you are accusing in this case.
Well, one thing that might help here, I think I see where your head
You
is
see-
represented, depends on what the elected official did wrong. For example, you said if they committed a crime, then that would be a criminal offense.
Well, if they
and
did
that'd be a little
something, we don't
different.
know that they committed a crime until
Or if
they
they,
go
if
to
they
court.
committed a tort, they still could be liable in their personal capacity for doing something wrong, and they could sue. You could
But-
sue
but-
them like you would sue me. So it kind of depends on what they did wrong. This bill really goes toward when the council and mayor act as a group, and they enact a law or they do something or don't do something that they're supposed to do. What you're really going to is someone who I think does something in more of an individual capacity,
Well,
something wrong.
but that's not what I'm hearing him say, and that's why I'm getting confused with it. What I'm hearing him
Right.
say is that instead of suing me as an
Yeah.
individual, if I do something that someone else thinks is, deserves to be sued about,
Right.
that I did it, but the city actually is the one that's named as the plaintiff. I mean, as the defendant.
In certain instances, because depending on what you did as, say, a city councilman or a mayor, you may get sued individually, and it may not really involve the city, and they don't even need to be named in the current law. So the devil would be in the details of exactly what you did, and if it's more of a criminal nature, obviously, we're talking about the sheriff or the police. If it's more of a civil nature, it could be a tort that you committed where you can be sued for negligence. But if it's an official act as a city, and that's usually when they act in concert with each other and pass
Or they take a
something.
vote, yeah.
That's right.
And-
Usually that's what that is. There could be some circumstances where it may not be, but usually it is. So I think what you're getting is you're looking for a remedy for someone who's
Yeah,
been
I'm just
aggrieved.
trying to make sure that
And there are other
citizens-
remedies outside
yeah.
of this, depending on what they did.
Okay.
Does that make sense?
No,
Mr.
that's
Yeah.
right. Yeah.
So you're heading in the right direction, but I think there's an answer to it, depending on what they did. This is just opening up even one more answer to something that went wrong.
Okay.
This adds another tool to that toolbox.
Okay, number 14, is that you, Representative? Go ahead.
That way.
You okay? Is that you, Ms. Holcomb, number 6?
Yes, sir. And I want to just echo a little bit of what you said and add to it, which is this would not undermine what our existing law is, which allows you to, without question, sue individuals in an individual capacity. That would
Correct.
still 100% remain. And so if that's a concern, then I don't think that this in any way affects that.
Good question, but this ain't gonna harm, that's your point, I think, right?
Yes.
Right.
Yeah.
Okay. All right, that's all the questions that I see from the table at this point. We do not have anybody signed up. Chairman Welch, you want to make some closing comments before we take it back to the committee
Yeah,
here?
I do. This amendment that you have before you, I'm looking at it, and I'm just going to raise this with you as you consider it. I said that I was supportive of it, but I'm reluctant because the language doesn't track exactly the language of the constitutional provision that we have here. It says individual, officer, entity, but we have a more exhaustive list in there. So I'm afraid that language actually may cause more problems than help. Secondarily, if it says in the court, if appropriate, well, that's not what we're trying to achieve here. We're actually trying to say that you'll have to refile it. And I think that's extremely important to achieving the purpose of subparagraph 2, is to ensure that people aren't named for political purposes, for bringing a frivolous lawsuit for some ulterior motive, and that should not be the case. If you have a sincere complaint, then bring it correctly. Dismissing it effectively works as a sanction to prevent that. So the language as it's written, I think, works more effectively to deter people who are just not paying attention or doing it for ulterior motives. So as I look at this language with more clarity, as we're sitting here discussing it, I'm going to withdraw my support for this language that's presented. I appreciate the individual who brought this to me and his thoughts. I think they're well-intended, but I think that this language, as if you were to consider it, would cause more trouble.
And then I would suspect in many instances, if you did not name the state appropriately and your lawsuit was dismissed, there's some exceptions, but many times you would be able to refile.
That's correct.
Many times. Mr. Dryer, is that you?
Yeah, Mr. Chairman, thank you. And Chairman Welch, first again, thank you for bringing this bill and for working on it for several years. I mean, for a democratic republic form of government, this is just foundational and one of the most important things to hold the government accountable. And I was just going to say, with this amendment, I would just foresee if there happened to be a negligence-based claim and someone were to, for whatever reason, throw in a declaratory relief claim, you would put a lot of discretion in the judge's hands at that point.
Yeah.
And so, without that amendment, this is a really important step forward. Thank you.
Thank you.
Okay, we had one person sign up, but I think they withdrew their name. I don't assume that do they want to change their mind? Okay. All right. All right. The bill is before the committee. Mr. Welch, you want to make a motion?
I'll leave that to the committee. Thank you.
You're part of it. Chairman Estration moves to pass. Is there a second? There's discussion. Number 8, is that you, Ms. Silcox?
I just said second.
Okay, all right. Any discussion? Hearing none, all those in favor of the bill is passed by substitute LC 4123026. Indicate affirmative. All right. LC 4123002S. Passed by committee substitute. All those in favor indicate by saying aye. Aye. Any opposed? You're off the rules again, Mr. Welch.
Thank you.
Thank you all. We may or may not meet on Thursday, so just watch for notices. And there may be subcommittees too. So I appreciate all y'all being here and have a good day. We're adjourned.